Hi, everyone. Welcome back to Becoming Counsel. Today, we're going to look at a criminal law and procedure essay for law students taking crim law and procedure. So, let's get started with a fact pattern. Let's say just after midnight, the police in the state of Illinois got a report of four men lurking behind a pharmacy that was just robbed 2 weeks earlier. Now, about 5 minutes after that report, Officer 1 and 2 stopped a car that was driving illegally without their headlights on, 1 block away from the pharmacy. Now, there were four men within the vehicle. Let's call them suspect A, B, C, and D. Well, Officer 1, after he pulled over the car, went to the driver, suspect A, and said, "You were driving without headlights. Please step out of the vehicle and hand me your license." Officer 1 didn't say so, but he did suspect suspect A to be involved in that earlier burglary that happened 2 weeks prior. And in fact, he planned to arrest him. As suspect A got out, Officer 1 saw a bulge in his jacket and he decided to pat him down to search for weapons. But he felt nothing suspicious. Now, wanting to hide his plan to already arrest suspect A, Officer 1 said something along the lines of, just hold on for a few minutes. You're not free to leave right now, but you will as soon as I finish writing up your ticket and checking your license. He then adds, "By the way, where are you guys coming from?" Now, suspect A responds, "I won't say anything without a lawyer." Now, Officer 1 responded and said, "Relax. I'm just trying to make small talk. We'll release you in a few minutes. Whether or not you answer, I was just curious where you guys were going tonight." Suspect A responded, "We were just coming from behind the pharmacy." Now, Officer 1 goes back to his vehicle. About 10 minutes go by, and other officers that are behind the pharmacy find incriminating evidence, and Officer 1 and 2 go ahead and arrest all four suspects and drive them to the station. Now, Officer 2 took B into the room and said, I need to tell you that you have all the rights of the Constitution, along with any Miranda rights you might have. Do you understand that?" Now, B responds and says, "Yes, but to avoid prison, I'll admit that me and my buddies broke into the pharmacy a few weeks ago. If you agree not to charge me, I promise to testify against others." Now, a different officer, let's call him Officer 3, took C to a different room and basically read aloud the Miranda rights. So you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney, and to have the attorney with you while you're getting questioned. And if you cannot afford an attorney, one will be provided for you. Now, he gave suspect C a copy of the document, let him read it, and then C basically said he understood. Now, through 2 hours of questioning, suspect C just sat there sternly and said nothing. Finally, Officer 3 said, "I'm not assuming you're exercising a right to remain silent. I don't read minds. So again, were you involved in the burglary?" Now, at that point, suspect C breaks his silence and says, "Okay, I was there 2 weeks ago, but only sort of to look out." Now, Officer 4 is with suspect D, and he wrongly believed that another officer had already given suspect D his Miranda rights. Now, the fourth officer took D to the county jail and spoke privately with a different cellmate. And basically, that cellmate was an inmate and a police informant. And he basically urged that person to introduce him to D, gain his trust, and asked about the robbery at the pharmacy, promising $50 to this inmate and a push for early release. Now, 3 hours later, inmate reports back and he said, "I did everything you asked." D bragged that he broke into the pharmacy 2 weeks ago and tried again last night. Now, 2 days later, state of Illinois charged all four with burglary and agreed to try them separately. Now, each one, suspect A, B, C, and D, all moved to have their own statements suppressed solely on the ground that it was emitted via a violation of the Miranda rights. So let's actually break down each of those statements and see whether or not the court should rule to include any of those statements. So let's start with suspect A. So the issue is, was suspect A in custody when he made the statement? Now, Miranda, from a rule perspective, Miranda rights apply only when an individual or a suspect is in custody. Custody means formal restraint or arrest, basically a restraint on freedom of movement to the degree associated with arrest, and a reasonable person can't find another alternative to get out there. Now, a routine traffic stop is generally not considered custody for Miranda purposes, even though the driver isn't technically free to leave. It's because it's brief and public. The officer's undisclosed subjective intent to arrest suspect A does not impact the Miranda right kind of application to his statement. So let's apply those rules here. So when suspect A answered saying that they were behind, so actually, let me take a step back. So when suspect A answered the officer, he was originally at a traffic stop. He was told he'd be free to go once the ticket was written up, and objectively, that's a stop, not custody. He didn't perceive he was going to be there forever. So the thing is, Miranda rights never attach to the situation. So his statement of, "I'll say nothing without an attorney," has no effect to the situation. There's no Miranda effect there. You can't invoke a right that hasn't attached yet, and the Miranda rights hadn't attached. And also, the officer's secret plan to arrest him is irrelevant to the objectiveness of this test. So any motion by suspect A to essentially suppress the comments he made, the conclusion there would be it would be denied. He was not in custody. His statements would be admissible. Let's look at suspect B, right? And the rules there is Miranda rights bar unwarranted statements that are a product of interrogation, like express questioning or functional equivalent, and a voluntary spontaneous statement not prompted by interrogation is admissible regardless of warnings, because there was no interrogation to trigger the rule. So when we apply it here, suspect B was in custody at the station. The officer warning was arguably vague, but it didn't matter because the officer only asked, "Do you understand?" And suspect B then volunteered his full confession and a plea offer without being asked anything about the crime. That's the definition of a spontaneous statement, not a response to an interrogation. So if he moved to try and get his statement suppressed, it would most likely get denied because the confession was voluntary, not a product of interrogation. Now let's look at suspect C. So there was an adequate warning and then just silence. So from a rule perspective, Miranda warnings need not to be verbatim script. They can be adequate if they're reasonably convey the four rights. And to cut off questioning, a suspect must unambiguously invoke the right to remain silent. Merely staying silent, even for a long time, is not an invocation of that right. So a suspect who then, is silent for a long time and then answers questions after a valid warning does waive his rights. So from, this perspective, Officer 3 did essentially outline all four Miranda points, right? The right to remain silent, anything he said can and will be used against him in the court of law, the right to counsel, including appointed counsel. And so C, even though he sat there for 2 hours in silence, he never invoked those rights. And he never said he was going to invoke those rights. And so when Officer 3 asked him again and C finally answered, he basically waived those rights and spoke voluntarily. So in conclusion, if C attempted to suppress his statements, they would be denied because even though the warning was adequate, there was no invocation of his rights, and then there was a valid waiver. So his statements would be admissible. So now let's look at suspect D, right? The one that was in the jail with the fellow inmate. And so Miranda applies to custodial interrogations by the police or their agents. So an informant working at the police station or working at the police direction within a prison, deliberately eliciting statements, that's an interrogation. Now, there is an exception where an undercover officer or informant questions a suspect who doesn't know he's talking to law enforcement because the coercive atmosphere Miranda guards against isn't present, but the officer here sincerely but wrongly believed that D had been warned. And D was charged in custody, kind of checking all the boxes there. Now, from an application perspective, the inmate was acting on Officer 4's direction. There was a payment, promised deal, told to gain trust, and asked specifically about the burglary at the pharmacy. Now, that's a state agent conducting interrogation of a suspect in custody with no valid warning. So from a pure Miranda theory perspective, the statement is a product of an unwarned custody interrogation by an agent. The strongest suppression case out of all four of these. And so what will most likely happen is for suspect D, the motion to suppress a statement would most likely be granted. And this statement would most likely be suppressed because it was an agent-directed custody interrogation without a proper Miranda right warning. I hope this has been very helpful. Thank you so much for listening.